So, very good evening, friends. Let us see some of the provisions regarding this Companies Act. These are the chapters: prospectus and allotment, share capital and debentures. And video lectures are already available on my YouTube channel, and I have shared the link also. So you can watch those video lectures and go through the entire contents. But let us see some of the important concepts here. Like in case of CSR. So if you talk of CSR, they could ask questions on this CSR spending. What are the companies covered in CSR? First of all, can anybody tell me whether this is in the syllabus or not? This CSR is covered in the syllabus or not? Have you seen? I think it is covered. If it is covered, then under which chapter?
Accounts of companies. Chapter
Accounts
9.
of company.
9.
Okay. Chapter 9.
Yes.
Okay.
कमांड स्ट्रक्चर नहीं बनते सीजर बना देखो
Chapter 9. So, who are the companies covered in this? Net worth above a certain limit?
yes net worth
Net worth of 500
crore rupees,
500
1,000 crores,
crores.
5 crores.
and turnover?
100 crore.
Five.
1,000 crore.
And net profit?
5 crore.
5 crores.
करोड़ 1,000 करोड़ 5 करोड़ 5 करोड़ नेट प्रॉफिट 1,000 करोड़ टर्नओवर 5 करोड़ नेट वर्थ
And you have to constitute a CSR committee for this. So how many directors will be there in that CSR committee?
3 or more, sir.
At
Okay.
least 3. One
Ah.
out of the one of the
Could
independent.
be
directors.
indirect.
One independent
Okay.
director.
And what is the spending required on this?
At
Last
least
time,
2%, sir.
So at least 2% you have to spend of the average net profits made during the
Last 3 years के
immediately
average.
3 immediate
preceding.
3 years
Preceding.
the average income.
And during CIRP, whether you can do this spending or not. Suppose your company is under CIRP, then whether you can spend this money or not. No, you cannot spend, because once moratorium is in vogue, so you cannot spend. So there is a restriction on spending during CIRP period. You cannot spend on CSR. And where to spend this CSR money? It is to be spent on projects or programs relating to activities which are specified in Schedule 7. So this was something about CSR. Now regarding this AGM, AGM also is a very important concept, that all companies, so there is only one company except OPC, they should hold an AGM at the end of each financial year. And a company must hold its AGM within a period of 6 months from the end of the financial year. However, in the case of first annual general meeting, the company can hold the AGM in less than 9 months from the end of the first financial year. In such cases where the first AGM is already held, there is no need to hold any AGM in the year of incorporation. Then do note that the time gap between 2 annual general meetings should not exceed 15 months. So these are some of the basic provisions. How much notice is required? The company must give at least 21 days notice to its members for calling the AGM. And 21 days clear notice is there. The notice clear days means that both the day of dispatch and day of receipt has to be excluded. The notice should mention the place, the date and day of the meeting, and the hour at which the meeting is scheduled. And the notice should also mention the business to be conducted at the AGM. To whom this notice need to be sent? A company should send the notice of the AGM to चट्टोपाध्याय जी, किन किन को पढ़ना है बताइए एक बार जरा, यहाँ से पढ़ के बता दीजिए. No issues. To whom this notice is to be given?
A company should send notice to AGM to all members of the company, including their legal representatives of a deceased member, and assignee of an insolvent members.
And what is a member? Who is a member? A member is a person whose name has been entered in the members register. So there is a register of members. So you have to go according to that. And you
Okay.
must have heard the concept of closure of the register. So closure is the period when no new entries are done. So there is a closure and opening of this members register, basically. It is basically for this purpose only. So they want to have a cutoff date. And besides members, किसको देना है notice?
Statutory auditors of the company,
हाँ.
all directors of the company.
Internal auditors को भी देना है क्या?
Statutory auditor को देना पड़ेगा. Internal auditors का तो बात है. In case of electronic communication, notice should be no.
So it
sir,
need not be given to internal
need
auditors.
not given.
Mhm.
The notice may be given in written through speed post or registered post via electronic media. Electronic media, the notice should be sent to the address of the member as per records of the company. In the case of electronic communication, the notice should be sent to the electronic email address of the members as per records of the company. The notice can be text typed in
Sir,
email.
all members means all shareholders, na?
Yes.
All
shareholders.
Basically, members means whose name is registered in the register of members.
सर इसमें भी एक बात है अगर मतलब शेयर्स का जो अनपेड शेयर्स होगा उसके लिए दो जो अनकॉल्ड शेयर कैपिटल्स के लिए
No. ऐसा है, they must have paid some money, na. Only then they must have subscribed to the share capital. Suppose out of 100, they have paid 50 rupees. So their name must be there in the members register. No?
they will also get the report.
Yes, everybody, yes.
In case of electronic communication, notice email address of the members as per records of the company. The notice can be text type in an email or an attachment to an email. The notice of the AGM should be placed in the website of the company or other website as many mentioned by the government. The AGM can be called.
Yes. This is very important. So an AGM can be called at a notice period shorter than 21 days.
Yeah.
Because I think during COVID period, so this was a matter of discussion that whether AGM can be called at a shorter notice. So in this case, this is the provision that AGM can be called at a notice period shorter than 21 days if at least 95% of the members entitled to vote in the meeting agree to the shorter notice. So if 95% or more agree, so this period can be shortened also. And the consent may be given in writing or through electronic mode. So this is important. This is an
How
important.
95% will agree, sir? Again, when they come only they will.
Huh?
When they are called for the meeting, then only they will say they will agree or not agree.
No, it says no, it may be given in writing or through electronic mode. Normally, actually, you see a practical situation. There may be 10 shareholders in a company. So in that case, if everybody agrees, it can be held at a shorter notice. No? So basically, this provision is intended for the companies where shareholders are not many.
Okay. sir.
Suppose there are 5 or 10 shareholders only, then 95% done. Okay.
The shorter notice means how much it can be short? 24 hours जैसे as per our system, COC meeting, at least 24 hours or 48 hours. In which, what is the shorter meaning which?
No, shorter means reasonable. 24, 48 hours, this much is reasonable. इतना तो होना ही चाहिए, इससे कम तो नहीं होगा.
Okay.
Now, what is the agenda of an AGM? So basically, we have to see some of the items are standard in AGM. We also might have received notices of AGM as a shareholder. So the matters to be discussed or business transacted in AGM consist of consideration and adoption of the audited financial statements, consideration of the director's report and auditor's report, dividend declaration, appointment of directors to replace the retiring directors, appointment of directors and deciding the auditor's remuneration. So this is the ordinary business. Actually, there are two types of business in an AGM. Ordinary business and special business. Ordinary business is specified that these are the items of ordinary business, and any other business apart from the above is treated as special business. Like here, appointment of directors to replace the retiring directors. So in case the appointment of directors is being done to instead of the retiring director, this director is to be appointed, then it is an ordinary business. But if a new director has to be appointed, then it has to be special business. Similarly, appointment of the auditors and deciding the auditor's remuneration, this is an ordinary business. So these are the ordinary businesses, and any other business apart from the above will be treated as special business.
Adda is the code word, sir.
Sir, an independent director will not attend the AGM, no, sir. It's not mandatory to attend the AGM.
Okay, great. Okay. The ordinary business of the company will be passed by an ordinary resolution where the votes cast in favor are more than the votes cast against the resolution. So they can also ask what is an ordinary resolution and what is a special resolution. In case of special business transactions, the resolution may be passed as ordinary. This is also very important. So in case of special business, it is not necessary that it has to be passed by way of special resolution only. Shiriji, ek minute. So the resolution may be passed as ordinary resolution or a special resolution depending upon the applicable legal provisions. A special resolution requires at least 75% votes in favor of the resolution. Now, Shiriji, please.
In AGM, audit committee directors or a chairman should attend. Okay. So in audit committee, in constitution of audit committee, independent directors are there.
Okay.
Okay. So there should be there can be an independent director.
Yes, sir.
Okay.
Sir, can I answer it, sir? It is not mandatory. It's not mandatory because I am
No,
also
but,
an independent director.
audit-
Who is attending-
Actually, Priya Venugopal ji is an independent director in some companies, so that is why she is sharing her practical experience.
Sir, as per law, I think independent director is the chairman of the audit committee.
No.
At the board level committee, there is chairman. Independent director may be a chairman.
Maybe a chairman, but he is not the chairman. Maybe
If
a
he is the chairman, then he will attend the AGM. This is sure.
No, actually, might be, but in our cases, all the independent directors will not be because normally we are in a government companies where the IAS officers being the chairman of the audit committee will attend the AGM and we will not be attending the AGM.
In government company, what is the limit for the independent directors? 2/3?
Yeah,
2/3,
yes,
correct?
yes.
That means during the AGM, 2/3 directors are not there. It is possible.
For an independent director to attend.
Yes, because
That is, sir, it
as far as
depends.
governance is concerned, independent directors are answerable to shareholder or members. Basically, because the trust on the independent directors are more than promoter or others.
But I'm saying it is not mandatory.
But the independent directors are made the
Actually-
chairman of the audit committee.
Actually, the provisions regarding board of directors are not in our syllabus. They are not
Okay,
covered in our
sir.
syllabus. So what
Okay,
we
sir.
can do is we
We'll
can discuss it in the group as a
Yes,
matter of for the purpose of knowledge, I think.
Okay,
Yes, sir,
okay,
yes.
okay.
Yes,
Thank you.
sir. Thank you, sir. Thank you. Sir.
Next is an AGM should be conducted during business hours only. So there is a specified time period during which this can be conducted between 9 AM and 6 PM only. Meeting can be conducted on any day which is not a national holiday. So there is a bar only for conducting meetings on national holidays, including holidays declared by the central government. Meeting can be held at any place which is within the limits of the city or town or village in which the registered office is situated. Now regarding this government company. A government company can also hold its AGM at any other place as the central government may approve. An unlisted company can hold an AGM at any place in India after obtaining consent from its members in writing or in electronic mode. In the case of section 8 company, the board decides the date, time and place of the AGM as per the directions given in a general meeting of the company. So these are some of the provisions regarding AGM. Then quorum for AGM. In case of private company, 2 members present at the meeting shall be the quorum. In case of public company, the quorum is dependent upon the number of members. So if the number of members is within 1000, then 5 members. If it is more than 1000 but within 5000, then 15 members. And if the number of members is more than 5000, then 30 members. And in case quorum is not present within half an hour, then the meeting will be adjourned to the same day in the following week for the same time and at the same place. So same day in the following week for the same time, and so place and time will remain same and the day will be changed to next week. Then members' right in an AGM. So it is not deferred to the next day, but it is adjourned to the same day in the following week. Then members' right. The members, including shareholders, are entitled to attend and vote. So members can cast their vote by a physical ballot or postal ballot or through e-voting. So members can appoint proxies and vote on their behalf. The proxy should be appointed in writing and the proxy form should be signed by the member. And in case the proxy is appointed by a corporate shareholder, the proxy form should be signed and sealed by an authorized secretary of the corporate. In case company is a shareholder, so this form has to be signed and sealed by an authorized secretary of the corporate. The members can elect one among themselves as the chairman of the meeting, or if the articles of association of the company provide for a chairman, such person shall chair the AGM of the company. So if articles specify the particular person to be chairman, then he will be the chairman. Otherwise, members can select among themselves to be one of them to be the chairman. Next is minutes. Every company has to prepare the minutes of the AGM compulsorily, and the minutes of the AGM means the written record of the proceedings of the meeting. So they state the events that took place and the resolutions passed in the AGM. Company secretary will record the proceedings of the AGM. Where there is no company secretary, any other person duly authorized by the board or by the chairman will record the proceeding. Minutes should be signed and entered in the minute book within 30 days from the AGM. The minutes book will be kept at the registered office of the company or at such other place approved by the board. Any member, shareholder of the company, upon request to the company, can inspect the minute books of the AGM on paying the prescribed fee. Because besides, why so much detail? Because besides Companies Act, rules are also in our syllabus. Upon request, the company will give a copy of the minutes of the AGM to the member within 7 days of the request. If the minutes are not given by 7 days of the request, the company shall be liable to pay a penalty of rupees 25,000. And every officer of the company who is in default shall be liable to pay a penalty of 5,000. So they can make a case study on these, that okay, you are a company secretary and you are required to hold an AGM. So what are the precautions you will take? Suppose you do not give a copy of the minutes of the AGM to someone, what can be the penalty levels? They can frame 2-3 questions on that. Now, extension of time for holding an AGM. The registrar of companies can extend the time available to hold an AGM by 3 months. So extension up to 3 months. And the company should apply for an extension through form this GNL1, specifying the reason for the extension and the period for which the company requires an extension. And the ROC will record the reasons for giving the extension. However, no extension is available to hold the first annual general meeting. So this is also important, that no extension is granted for the first annual general meeting. What could be the reasons? Mergers and acquisitions, delay in finalizing the financials, delay in audit report due to absence of auditors because of reasons such as death, resignation, incapacity to sign, or other such valid reasons. Information loss in a computer due to virus or system related issues. Non-readiness of the economic records due to natural calamity, loss of commercial data, vacancy of directors, change in a financial year, non-availability of shareholders leads to the absence of a quorum, non-availability of directors on valid grounds. For example, there is a sudden demise of a director due to which the limit of directors goes below the minimum requirement of directors. Then confiscation of books by the IT department, serious and fraud investigation cell, or other government officials. So these are some of the grounds on which extension could be sought. Then what are the steps for filing an application seeking time extension for conducting the AGM? The directors of the company, they will initiate a meeting of the board of directors concerning which notice has to be sent to all the directors 7 days before holding the board meeting. And they will hold a board meeting on the particular date mentioned in the notice. They will pass a board resolution for time extension. So board resolution is required for, and 7 days notice is to be given to all the directors. Then they have to fill this form, etc., etc. Next, reporting. So there are some events which are to be done after the conduct of the AGM. So how this has to be reported? So after the conduct of AGM, every listed company has to file a report on the AGM in this MGT 15 within a period of 30 days from the conclusion of the AGM. So you can check the latest forms if there is any change, because these forms keep on changing. Then consequences and penalty for default in holding an AGM. So in case a company fails to hold an AGM within the stipulated time or extension, the tribunal may itself, on an application made by a director or member, order an AGM to be conducted as per its directions. And if the company further defaults in holding an AGM in accordance with directions of the tribunal, the company and every officer of the company who commits the default shall be punishable with a fine of up to rupees 1 lakh. And in case of continuing default, a fine of rupees 5,000 per day is levied for each day during which the default continues. Now, there are provisions regarding this virtual AGM also, which came during COVID period. The notice must include the framework laid down by the circular. As per there was a general circular. The following matters must also be stated while publishing. A statement that EGM has been conveyed as per the Act and the provisions of the general circular. Date and time of the EGM through VCM or audio visual means. Then availability of the notice of the meeting on the website and stock exchange. Details of how members not having registered email address can vote. Remote e-voting or e-voting during the meeting. Then manner in which the email address of the members can be registered. So these are some of the provisions regarding this e-voting. The manner in which the members holding physical shares and not registered their email addresses can cast their vote through remote e-voting. Then manner in which the members can opt to receive dividends directly into their bank accounts via ECS. Any other details. So in the current circumstances, the notices can be sent via emails registered with the company or depository participants. Before sending out notices together with the financial statements, company must publish at least once in a vernacular newspaper in the district in which the registered office of the company is situated, and one English newspaper also, preferably having electronic editions. So these are some of the provisions regarding meeting, EAGM. And due to the difficulty in sending out physical copy of the financial statements, including board's report, auditor's report, or other documents, so they can be sent via email. Then dividend dispatch measures. The companies can make adequate arrangements to allow the members to give their mandate for receiving dividends directly in their bank account through ECS or any other means. Then matters considered in the AGM. Only the items of special business considered to be unavoidable by the board may be transacted apart from the ordinary business. Then mode of conducting the business. So it can be conducted through video conferencing or other audio visual means. And where it has to be conducted, at any other place in the district where the registered office of the company is located, taking cautionary steps as stipulated. It can also hold meeting virtually with some members physically present and providing the facility of video conferencing or other audio visual means for allowing other members of the company to participate in such meetings. Then quorum. All the members physically present in the meeting and those attending the meeting through this e-facility shall be taken together for arriving at the quorum. So for deciding quorum, members physically present as well as members through this facility of virtual conference. And how is voting done? So all the resolutions will continue to be passed by the facility of e-voting system. Then how many AGMs must be conducted in a year? A company other than OPC must conduct at least one AGM in a financial year. And the first AGM, that is a newly incorporated company, it should be held within 9 months from the close of the first financial year, as the company doesn't need to hold an AGM in the year of its incorporation. Which section of the Companies Act contains provision? 96. Then do AGM rules apply to a general meeting? So there are many types of general meetings in a company, which are annual general meeting, extraordinary general meeting, meetings of members, meetings of creditors. or debenture holders. All rules that apply for a general meeting is provided from section 101 to 112 of the Companies Act. And these are the rules. The rules regarding the procedure to hold AGM, quorum, members' rights, and minutes of an AGM apply to all the general meetings of the company. Now, can we hold an AGM on a Sunday?
No.
No, public holidays.
Yes. An AGM can be held on any day, including a Sunday, unless the Sunday is a national. No, there is
National
no-
holiday.
So only on national holidays you cannot do AGM.
Hold
Otherwise,
it.
you can do AGM. However, the AGM should be held during business hours, that is between 9 a.m. and 6 p.m. on a Sunday. Can an AGM? Huh?
2nd October is a
No,
national
no,
holiday.
that is a national holiday. 2nd October, 26th January, and 15th
15th
August.
August.
Can an AGM be held outside India? The AGM should be held at the registered office or any place within the city, town, or village where such a registered office is situated. In the case of an unlisted company, an AGM can be held in any place in India if all the members consent to it in advance, either in written form or through electronic. However, the central government is empowered to exempt a company from the AGM provisions, subject to the conditions it may impose. Thus, a company can hold AGM outside India if it applies to the central government to relax the provisions of section 96 of the Companies Act and allow it to conduct AGM outside India. Otherwise, AGM cannot be held outside India. Can an AGM be held on a public holiday? Yes. An AGM can be held on a public holiday. Companies Act states that AGM cannot be held on a national holiday. However, the act is silent on public holidays. Thus, a company can hold an AGM on a public holiday also. Now, which are the national holidays? So there are 3 national holidays: 15th August, this Gandhi Jayanti, and 26th
26th
January, Republic Day. So AGM cannot be held on these 3 days. If an adjourned AGM falls on a national holiday, can the AGM be held on that day? Yes, an AGM cannot be held on national holiday. However, no specific provision restricts an adjourned AGM to be held on a national holiday. Thus, an adjourned AGM can be held on a national holiday as the original scheduled date of the meeting was not on a national holiday. Can AGM be held through video conferencing? Yes, we have already seen the provisions. It can be held, particularly due to COVID, this came. Now, something regarding annual return. So what is the company annual return? Annual return, we will do some question answer also. Annual return is an annual yearly form or return which contains information regarding the company, its shareholders, directors, KMP, etc. as on 31st March and is filed with ROC. So it is a mandatory requirement and a company files the form MGT 7 for its annual return. So what are the sections, rules and provisions? Section 92, Rule 11 and 12 of the Companies Rules. Applicability of company annual return. It is applicable to all classes of companies, including OPC and small companies. Now, due date for filing of company annual return. Form MGT 7 is to be filed within 60 days from the date of the annual general meeting of the company, and the due date for regulating annual general meeting is on or before 30th day of September following the close of every financial year. Therefore, the last date for filing form MGT 7 is generally 29th of November because it is 60 days, not 2 months. Normally it is 29th of November every year unless extended by MC. Suppose there is a small company, so will it be required to file the return? Yes, as per section 92, annual return also has to be filed by a small company. Now OPC, whether OPC is also required to file this return? Yes. As per section 92, annual return also has to be filed by an OPC. My
Abridged
company is a
form. Abridged
Yes,
form, sir. Abridged form of annual return, sir.
okay. So my company is a private limited company and not doing any business since years. So should we need to file this return? Yes. As long as the company is showing is active and dormant status has not been obtained from ROC. Otherwise, you have to apply for dormant status. If your company is being shown as active, then you have to file that return. My company is a listed company. What additional requirements with regard to filing of annual return needs to be ensured? The annual return also needs to be certified by a practicing company secretary. And what is the certification by a practicing company secretary? Every listed company and unlisted companies having paid up capital of more than 10 crores or turnover more than 50 crore shall require to attach a certificate in MGT8 along with the annual return to be filed with the ROC. Is annual return, whether this can be certified by a practicing advocate? No. Annual return is only to be certified by a practicing company secretary. So practicing chartered accountant or practicing cost accountant or an advocate cannot certify this return. Only it has to be certified by a practicing company secretary. My company has not filed INC 22A. Will it be able to file annual return? Yes, the company can file this MGT 7. Some of the directors of my company, they have not filed director KYC. Can the company file annual return? Yes, the company can file annual return, but the DSC of the defaulted director cannot be used. Who will sign the annual return? For normal company, director plus company secretary, if any. If no company secretary, then by a practicing company secretary. So director plus company secretary or practicing company secretary. And for OPC or small company, company secretary, and if there is no company secretary, then by a director. So no need to sign from any practicing company secretary in case of OPC or a small company. My company does not have full-time company secretary. Who should sign the annual return? So as per section 92, if the company doesn't have a full-time company secretary, then the annual return can be signed by a practicing company secretary along with the director. The company secretary of the meeting company has signed the annual return. Will it again to be signed by a practicing company secretary? So it depends upon the status of the company. As I've already told you, if it is a listed company or it is a company having specified turnover or capital, then in addition to the company secretary of the company who is signed, it has to be signed by a practicing company secretary also. In other cases, if your company is listed or it doesn't have turnover more than 150 crores or paid up capital is 10 crore or less, then it need not be signed by a practicing company secretary. Can MGT 7 and MGT 8 both be signed by the same practicing company secretary? Yes. My company has not filed annual return for last 2 years. Can it file now for the current year and past years? Yes. So it can file for current year and past years by making additional fees. And all the directors of the company have resigned or disqualified under section 164. Then how to file the annual return? It is advisable to get a director appointed from backend by ROC and then get the same filed. Annual return shall contain the data as on end of financial year or as on the date of AGM. So up to what date the data should be there in case of this annual return. So this has to be as on the closure of the financial year and not as on the date of the AGM. So the data of 31st March, it has to be given. Any event if occurred after 31st March, will it also be captured? So annual return, it contains the data or information as it stood on the end of the financial year, but the annual return shall also contain any event occurred after 31st March in case there is change in director or KMP. This is also important. Then the annual return of my company, it is filed with wrong information. Can it be rectified? Yes, it can be after the same is cancelled by ROC. Then AGM of my company has not been held. How the annual return will be filed? So as per the provisions of section 92, if there is no AGM held, then within 60 days from the date on which the AGM should have been held. So whether your AGM has actually been held or not, it is not important. So from the due date of holding the AGM, within 60 days, you have to file the annual return. MGT 7 also should be attached with the reasons for not holding the AGM. AGM of my company has been extended by ROC. How the annual return will be filed? It will be filed within 60 days from the extended date of the AGM. Our company has not filed form DPT3. Will it be allowed to file annual return? Yes. What are the penalty consequences for late or non-filing? Late filing is 100 rupees per day. As penalty up to maximum 5 lakhs. Plus company and its officers who is in default shall be liable to pay penalty of 50,000. And non-filing, this is for late filing, and for non-filing for continuous period of 3 financial years will lead to disqualification of directors. And additionally, after the Companies Amendment Act 2019, delay filing of annual return will also amount to adjudication by ROC after issuing of show cause notice. My company has filed annual return with additional fees. Will it be relieved from all the liability? No. After the Companies Amendment Act 2019, delay filing of annual return will also amount to adjudication by ROC after issue of show cause notice. Additional fees is not a fine or penalty. So besides paying this additional fees, you will be required to you will be issued a show cause notice also. Yes, Priya Gopalji.
Sir, it is the fine is 2 lakhs or 5 lakhs, sir.
Okay,
I think it's maximum of 2 lakhs, sir.
okay. Now my company is under NCLT. Will it still be required to file annual return, and who will sign? RPO director. In this case, I think IP, he files a form INC 28, and then he signs all the documents on behalf of the company. My company has paid up capital of 10 crores and above and do not have company secretary. Who will sign the annual return and MGT8? It has to be signed by a director and a practicing company secretary. Can an alternate director sign MGT7? Yes.
Sir, signed by RP or RP can also sign, sir. Suppose
RP can
NCLT
sign. RP, first of all, what happens is RP, as soon as he takes over the company, he files a form INC 28 at the MCA website, and he is then designated as CEO of the company. So in that capacity, he signs all the forms. So he will be signing the annual return.
So there is a circular for this CIRP companies.
Okay.
So, no, there is no penalty for late filing. Like if RP has to comply the all previous records, so there is no penalty.
Okay. So you can post that in the group also for the information
Yes,
of all.
okay, sir.
Can a PCS sign annual return of the company even if the company has company secretary? No. Only PCS can sign certification if it is a listed company or paid up share capital is more than 10 crore or turnover is more than 50 crores. My company is a dormant company. Will it be required to file MGT7? So if dormant status is taken from ROC, then it's not required. But as long as the status is active, you have to file. What are the attachments to be done? List of shareholders, debenture holders, if any, then approval letter for extension of AGM if applicable, then copy of MGT8, optional attachments. My company was not able to file annual return this year. Can they file it next year? Yes, but after payment of additional fees. Annual accounts of my company is not audited. Can we file annual return? Yes. The accounts of my company is not adopted in the AGM. How can we file annual return? You can still file. My company secretary joined after end of the financial year. Can he sign the annual return for the past period? Yes. Paid up share capital of my company is less than 5 crore. Do the MGT7 also need to be signed by the company secretary? If the company has company secretary, then yes, or else any director can sign and a practicing company secretary will also sign. We have already applied for striking off of my company. Will it require to file MGT7? Yes. Even if you have applied for striking off the name, still you are required to file the annual return MGT7. My company has applied for voluntary winding up. Is it still required? Yes. So even if you have applied for voluntary winding up or striking off, even in case of CIRP, you are required to file the annual return. So can an additional director sign? Yes. Additional director, alternate director, they can sign. Should we upload the copy of the annual return on our website? It is not required. So section 92(3) is not effective. But if a company wishes to do so, it can. My company has made non-compliance in filing DPT3 and MSME return 1. Should it be captured? No. The non-compliance has been made during this, so it's not much relevant. Then regarding bonus shares, let us see regarding some of the provisions regarding bonus shares. So this link I have already shared in the group. I hope you must have already gone through this link. This link was shared 2-3 days back. But let us see some of the provisions regarding issue of bonus shares, which are otherwise also we are aware that bonus shares, first of all, bonus shares cannot be issued in lieu of dividend. Dividend is separate, bonus shares are separate. You cannot say that, okay, this year we are skipping the dividend, but we are issuing you bonus shares. So a company may issue fully paid up bonus shares to its members in any manner whatsoever out of its free reserves, securities premium account, means share premium account, or capital redemption reserve account, provided that no issue of bonus shares shall be made by capitalizing reserves created by the revaluation of assets. So if your assets were earlier of 100 crores, now you have got them revalued at 300 crores, and that 200 crores you have shifted to capital redemption reserve, then you cannot issue bonus shares out of that capital redemption reserve account, which has been created by capitalizing reserves created by revaluation of assets. Then no company shall capitalize its profits or reserves for the purpose of issuing fully paid up bonus shares unless, first of all, you have to be authorized by the articles. Then it has, on the recommendation of the board, been authorized in the general meeting of the company. Then there should not be any default in the payment of interest or principal in respect of fixed deposits or debt securities issued by it. So if there is any default, then you cannot issue bonus shares. It has not defaulted in respect of the payment of statutory dues of the employees, such as contribution to provident fund, gratuity, and bonus. So there should be no default on that account. The partly paid up shares, if any, outstanding on the date of allotment, are made fully paid up. So they have to be first made fully paid up before issue of bonus shares. Then it complies with such conditions as may be prescribed. So for that, we have to see the rules for issue of bonus shares. And the bonus shares shall not be issued in lieu of dividend. So these are some of the requirements regarding issue of bonus shares. Now let us see the rules regarding issue of bonus shares. So what are the prerequisites? So prior to the issue of bonus shares, there are some conditions that must be ascertained. First of all, you have to see that articles authorize it. If not, then the articles of association needs to be altered in accordance with section 14 of the Act. Verify that the authorized capital is sufficient for the issue of bonus shares. It's not that after the issue of bonus shares, your authorized capital exceeds the limit. If it is not, then the memorandum of association has to be altered to increase the authorized capital. The issue must be authorized at the general meeting by the shareholders, and you have to ensure that there are no defaults in payment of principal or interest of fixed deposit or debt securities. Then no defaults in statutory dues. Then you ensure that all the shares are fully paid, and company must check the availability of all its resources. What are the procedures? You have to call a board meeting. So first step is to call a board meeting as per section 173(3). The issue of notice must be at least 7 days before the board meeting. Then you convene the board meeting. Company must then hold the board meeting and place the agenda. To convene the meeting, the following, Haji, Shirish ji, please.
Sir, I'm having doubt regarding this bonus shares. Suppose, suppose there is an application under section 8 or 9. Okay, means operational creditors, CRP.
Okay.
So can company issue a bonus?
I don't think so. Company can issue a bonus because company cannot even spend on CSR.
Correct. That is there.
Actually, basically, the role of RP is to protect and preserve the assets.
Okay.
So it will not be permitted.
Thank you.
But sir, bonus share does not incur any liability. It is just a book entry, right?
Okay. I think we can discuss it later. We can discuss it in the group. So let me revert back. Let me study it further and then I'll revert. So following are the steps to be added by the company. First is you have to call a board meeting. Then you have to convene the board meeting. And you have to ensure that the meeting has the required quorum, that is 1/3 of the total strength of the board. You place the board resolution for approving, subject to the approval by the shareholders in general meeting by an ordinary resolution. And ratio of bonus shares must be fixed. And you decide the date, time, and venue for the general meeting and authorize a director to send notices for the same. Then you have to circulate the draft minutes. Then you have to send the notice of general meeting. You have to convene the general meeting. You have to convene a board meeting. Then you have to file this form number PS3 and issue of share certificates. So these are some of the rules. What are the advantages? It can help the company to conserve cash by issuing shares in lieu of dividends. So you are, instead of cash, you are issuing shares. It brings about a balance in the pricing of the shares. Since the issue is only a book entry, the total shareholding is constant. However, the number of shares has increased. And it brings the share capital in line with the assets employed, and it helps in capitalization of the reserves. So for a shareholder, it increases the investments of the shares and it is tax-free. It assures the company's policy for long-term growth and increases the cash dividend receivable in the future as the number of shares held by the shareholder has increased. So rule number 14 talks of this issue of bonus shares. I think we have already gone through all these things. So generally, new companies, they would like to issue a bonus, and mature companies would prefer to give cash dividends. From now onwards, this PPT I have already discussed in my video lecture, which is available on my YouTube channel. I think I've already shared the link, or otherwise you can also see the link. Let me show you the link. Just a minute. So let me share my screen. This is my YouTube channel. So on this YouTube channel, you have to click the playlists. So if you click playlists, then you will find various playlists here. So you can click on the lists for this allied laws. And in allied laws, there are various just a minute. Companies Act. So there are two sessions on Companies Act, 1 and 2. So from here it will start. So I've discussed it section by section. So you can go through this. Okay. Now let us do some of these questions from the book. Let me ask you some questions on Companies Act. So can anybody tell me what are the consequences if a company with intent to fraud issues duplicate certificate of shares?
Seven years imprisonment.
The company shall, the answer is given in section 46 subsection 5. The company shall be punishable with fine, which shall not be less than 5 times the face value of the shares involved in the issue of the duplicate certificate, but which makes 10 to 10 times the face value of such shares, or rupees 10 crores, whichever is higher. And every officer of the company who is in default shall be liable for action under section 447. So the answer is given in section 46 subsection 5. not less than 5 times the face value, but it may extend to 10 times the face value or rupees 10 crore, whichever is higher. And every officer of the company who is in default shall be liable for action under section 447.
No imprisonment, sir.
It says it shall be liable for action under section 447. And 447 contains provisions regarding imprisonment also. If we see section 447,
Seven years or 10 years.
yes, these are the provisions. So 447 talks of fraud and all punishment, etc. So this is
10
included in this PPT.
5 years,
10 years.
10 years and
6 months to 10 years.
10 years. 5 years is also there.
It depends whether public interest is involved or not.
Yes, sir.
In case of fraud, 10 years imprisonment is there maximum.
And does not involve public interest, 5 years.
Let us see something on registration of charges. So all these things I have already discussed in detail, so you can go through that video and I think it will be clear regarding this charge. So on which assets a company may register the charge? Suppose assets are situated outside India, so whether it can create a charge or not?
Yes, sir. Subcharge.
Yes, so it can create a charge on the assets situated in India, outside India, tangible assets or otherwise. So
Intangible,
even in
all
respect
life.
of intangible assets, it can create a charge. And within what is the period within which this charge should be registered?
30 days, sir.
Yes. And what is the time period for registrar to allow registration? Because this creation of charge, this came on Companies Amendment Ordinance 2019. So they may allow, okay, you can create a charge within 300 days of such creation.
Before the commencement.
Yes,
sir.
yes. And the
After
registrar,
it,
the registrar may, on an application by the company,
60 days,
allow such
after 60
registration to
days.
be made in
once
case of charges created on or after the commencement within a period
60
of,
days, sir. 60
So-
days.
in this case, it is 60 days. Yes. And who will bear the cost of the fees paid to the registrar where registration is effected on
The person whose favor में charge हो रहा है.
on the application of the person in whose favor the charge is created?
Cover the fees.
The person in whose favor the charge is created shall be entitled to recover from the company. And the provisions of section 77 relating to registration of charges shall be applicable to, suppose there are two types of companies. One is a company acquiring any property subject to charge within the meaning of that section, or any modification in the terms or conditions or the extent or operation of any charge registered under that section. So it applies in both the cases, in whether a company is acquiring any property subject to a charge or any modification in the terms of conditions or the extent or operation of charge. So in both cases, the provisions of section 77 apply. So where any charge on any property of a company is registered under section 77, any person acquiring such property shall be deemed to have notice of the charge from the date of such registration. So it is a deemed notice. Deemed notice is given in section 80. Then section 81. Who may inspect the register of charges kept by the registrar?
Any
Any
person.
person.
Any
Anybody, sir.
person on payment of prescribed
Prescribed
fees.
fees.
Yes.
Prescribed fees.
And what is the time limit within which a company shall give intimation to the registrar of the payment or satisfaction in full of any charge registered?
300 days.
Within 30 days, sir.
Within a period of 30 days.
30 days.
Section is 82. Then, if any person obtains an order for the appointment of a receiver of or to manage the property subject to a charge of a company, so within what time period he will give notice of such appointment to the company and the registrar?
It is also 30 days, sir.
Yes. So
Within a
it is
period of
also 30 days. Section
It is also 30.
84. So if a person is appointed as a receiver or liquidator, he will intimate within a period of 30 days. Next is, who can inspect the register and instrument of charges kept by the company during business hours?
Auditors.
Any member without any
members,
payment of fees,
any payment fees.
creditor without any payment of fees, by any other person
Any other
on
person.
payment of fees. So section 85, it talks of. So for members and creditors, it is free, and for others, it is on payment of fees. Section 85. If any company is in default in complying with any of the provisions relating to registration, the company shall be liable for a penalty of, what is the penalty?
5 lakhs, sir.
Yes, 5 lakh rupees. And it is given in section 86.
6.
Acha. If any company is in default in complying with any of the provisions relating to registration of charges, every officer of the company who is in default shall be liable to a penalty of,
50,000.
yes, 50,000. And which form is to be used for registration of or creation or modification of charge?
CHA 1. CHG 1.
Yes. And which form is to be used for registration of creation, modification of charge for debentures?
9 है sir.
CHG.
9 से most
मैं
of
आपको इसलिए पीपीटी में दिखा रहा हूं तो पता चल जाएगा आपको पीपीटी में lot of coverage is there.
हाँ सर. देख ही रहा हूँ सर.
In which form the certificate of registration of charge shall be issued by the registrar?
CHG 2 तो है.
CHG. Yes. And certificate of registration of modification of charge shall be issued in form?
CHG 3 है.
Yes, CHG 3.
3 है. एक फॉर्मूला है, फॉर्मूला से होता है सर.
ओके, क्या फॉर्मूला है?
इनिशियल देखो 1 करेंगे, 1 से बाद 9 होता है डिवेंचर के लिए. 1 के बाद हम जो 1 देंगे तो उस रजिस्टर 2 देगा. हम 3 करेंगे, ऐसे करके फॉर्मूला से चलता है सर.
Okay.
मिस्टर अग्रवाल.
And particulars of satisfaction charge shall be filed in
CHG 4 है ना. CHG 4 है. हाँ.
CHG 4. Acha, management and administration. Let us see some of the questions on management and administration.
So they can ask the form also, sir, if possible.
But they can ask anything. Act, rules, everything is in syllabus. But try to remember as much as possible. Achha, regarding this beneficial owner, let me ask you something on this. Section 90. So who is a significant beneficial owner? What percentage is there for a
25%.
25%.
Yes.
Not less than 25%.
Yes, not less than 25%.
Means what, sir? We are not aware of this.
Actually, a person is considered to be a significant beneficial owner if he holds every individual who acting alone or together with or through one or more persons or trust, including a trust and persons resident outside India, holds beneficial interest of not less than 25% or such other percentage as may prescribed in shares of a company, or the right to exercise or the actual exercising of significant influence or control over the company is called as significant beneficial owner. The purpose is actually in case of substantial acquisition and takeover. Basically, the idea is from there. Who will sign the annual return? We have already seen. Director and company secretary, or company secretary in practice where there is no company secretary, or signed by two directors when there is no company secretary. So any of them can sign the annual return. Whether they can be extension of first annual general meeting or not?
No, sir.
No. But other than first, for how much period the registrar may extend?
3 months.
yeah.
3
3
months,
months.
yes. What are the business hours?
9 to 6.
9
sir.
to 6.
Yes, 9 to 6. So. And these notes I prepared during lockdown period. I just took the act and I wrote down on a piece of paper. So these are my own notes, which I made during lockdown period because I was free during that time.
पिछला कंपनी साइड भी बहुत अच्छा सब बना है.
हाँ?
पिछले कंपनी एक्ट का स्लाइड जो है बहुत अच्छा फ्रूटफुल लग रहा है एग्जाम के लिए.
हाँ, एग्जाम पर्पस सही है बेसिकली.
बहुत सुंदर. उतना डिटेलिंग नहीं पढ़ना पड़ेगा.
हाँ, इतना even if
उतना
you
कहाँ
read this
चाहिए?
much ना, I think it is sufficient.
Sufficient है. बहुत इफेक्टिव है वो पिछले स्लाइड्स जो मैं देख रहे थे कंपनी का. शेयर कर दिया ना सर इसको?
I think I have already shared.
ओके सर देख लेते.
Group
Yeah,
में डाल
already
दिया.
shared, sir.
ओके सर थैंक यू सर देख लेते.
Management and administration, sir. Please tell something about that.
Okay. वैसे तो देखो सारा आपको मिल ही जाएगा उसमें. Regarding
Yeah, this
management
one.
and administration, these are some of the things. Let me ask you some questions on it. I will show you and then I'll ask you. Regarding annual return, I've already discussed in detail. Regarding AGM, etc., I've already discussed. तो एनुअल रिटर्न में तो आई हैव ऑलरेडी डिस्कस ना एवरीथिंग. और उसमें क्या डिस्कस करना है? अच्छा. नाउ you tell me whether a proxy holder, whether he should be a member of the company or he need not be a member.
Need not be a member. Sir.
Yes. So proxy need not be a member.
Section 8 company में must है.
Yes.
In Section 8 company, proxy should be a member of the company.
Who shall be the chairman of AGM? Chairman, regarding chairman, I told you.
Already article association prescribe करे तो वो होगा. Otherwise, members voting.
The members personally present at the AGM or EGM, they shall elect one of the themselves to be the chairman unless articles specify.
Okay.
Now let us see some of the provisions regarding this valuation. Valuation कभी पूछ लेता है वो. In case a company is the registered valuer, who shall sign the valuation report and act on behalf of the company? Managing director, company secretary, any director authorized by the board of directors, or only the registered valuer?
Any director authorized by.
No, only the registered
Only
valuer.
registered valuer,
Valuer.
only registered valuer.
So in case a company is the registered valuer, only the registered valuer can sign the valuation report and act on behalf of the company. And in case a partnership entity is the registered valuer, who shall be liable for the acts in respect of a valuation assignment? All the partners shall be liable jointly and severally, along with the partner who signs and acts in respect of a valuation assignment on behalf of the partnership entity. Who shall be liable in case company is a registered valuer? The company shall be liable along with the director who signs and acts in respect of a valuation assignment on behalf of the company.
Sir, it is given in the rules, sir.
Yes. There are valuation rules.
Okay, sir.
And these valuation rules are in our syllabus.
Okay, sir.
No slide on that, sir.
There is a slide. Regarding this compromise arrangement also, I made 1-page summary. So in this 1-page summary, you can get a gist. And there is a case study also. There is a case study by Manju Mundra ji. We will invite her once again for case study on this compromise arrangement.
The winding up भी तो syllabus में है ना सर हम लोग.
बाइंडिंग अप भी है, वो भी करेंगे.
वो भी क्वेश्चंस आता है बीच में.
उसको अलग से करेंगे बाइंडिंग अप. बिल्कुल
जरूरी
करेंगे.
है.
ये है कंपनी रजिस्टर्ड वैल्यूएशन रूल्स. तो दीज आर द फॉर्म्स और ये सारा इसमें दे दिया हमने. ज्यादा नहीं दिया है बट थोड़ा सा इसको और कर लेंगे डिटेल में. Removal of names. Now let us discuss something about this removal of names. What are the provisions? So what are the circumstances when the registrar shall send a notice to the company and all the directors of the company? If a company has failed to commence its business within 1 year of its incorporation, or company is not carrying on any business or operation, or the subscribers to the memorandum have not paid the subscription, then the registrar may send a notice to the company and all the directors of the company for removal of the name. How can the company suo motu file an application to the registrar for removing its name? They can pass a special resolution after extinguishing all their liabilities and by obtaining consent of 75% members in terms of paid up share capital. And this order of the registrar notifying a company as dissolved under section 248, it may be filed within a period of 3 years from the date of the order of the registrar. And what is the maximum time available to file an application before the tribunal by a company? Before the expiry of 20 years from the publication in the official gazette of the notice. Actually, there are certain situations where the company's name has already been struck off, but they want to revive the company because there are some income tax liabilities or some other person is interested in revival of the company. So in that case, within 20 years, he can make an application before the tribunal to revive the name of the company. But after 20 years, no such application can be made. Regarding winding up, what could be the grounds of winding up? A company may pass a special resolution for winding up the company. Actually, this winding up of the company, it has now been broken into two portions. One is when you wind up your company, if you have made a default, then you can go in section 10 of the IBC. or in case you want to voluntarily liquidate the company, then you can go as per the provisions of section 59. So section 10 and 59 and the other grounds are here only. So grounds for winding up of a company, if you pass a special resolution or you have acted against the interest of the sovereignty and integrity of India, decency, morality, or if on an application made by the registrar or any other person authorized by the central government, the tribunal is of the opinion that the affairs of the company have been conducted in a fraudulent manner or there was a fraud in formation or management of the company, they may issue the orders for winding up. Petition for winding up of a company, it may be filed by the company, it may be filed by the contributory, it may be filed by the registrar or any person authorized by the central government. There are penal provisions against the director or officer in case of failure to complete accounts and audit. Punishment, punishable with imprisonment for a term which may extend to 6 months or with fine, which shall not be less than 25,000, but it may extend to 5 lakhs or with both. And in this case also, insolvency professionals are appointed as liquidator. In this case also, there is a winding up committee, like we have got stakeholders consultation committee in case of liquidation. So in case of winding up also, there is a constitution of a winding up committee which monitors the progress of liquidation. And this committee has to be set up within 3 weeks from the date of passing of the winding up order. And the company liquidator shall make an application through the tribunal for constitution of a winding up committee and to monitor the progress of liquidation. What is the composition of this winding up committee? Official liquidator, which is attached to the tribunal, the nominee of secured creditors, and a professional nominated by the tribunal. And as we have got section 14 moratorium, so similar section is here, section 279, which talks of effect of passing of winding up order or appointment of a provisional liquidator, no suit or other legal proceeding, similar to section 14. So no suit or other legal proceeding shall be commenced. If other legal proceedings are pending, they can be proceeded with by or against the company only with the leave of the tribunal, and no effect on the proceedings pending in appeal before the Supreme Court or High Court, something similar to section 14. Then there is a repayment schedule similar to section 53. But there is a slight change here. The government dues are paid first. But in case of section 53, government dues are at a lower priority. And first of all, there is a pari passu eligibility of this workman dues and secured creditors, similar to, because after insolvency resolution process cost, we have to pay to the workman 24 months dues and to the secured creditors on a pari passu basis. So similar provision is here. So suppose the security is 1 lakh, workman dues are 1 lakh, secured creditors are 3 lakhs. So total liabilities are 4 lakhs, security is 1 lakh. So the workman will be paid 25% and secured creditors will be paid 25% of their dues. What is the order of payment? It is completely opposite to section 53. Here, first of all, revenues and taxes due from the central government or state government are payable within 12 months. Then all wages and salary payable within a period not exceeding 4 months. Then all accrued holiday remuneration becoming payable, amount due on death or disablement, provident fund, expenses of investigation. And there are similar provisions like PUFE transactions, similar to those. Section 334 is there. In case of winding up by the tribunal, any disposition of the property, including actionable claims after the commencement of winding up, shall be void. So you cannot dispose of any property after a winding up order has been made. And you cannot put any property to attachment or distress or execution. That shall also be void. So if you correlate these provisions with the IBC, you will be able to quickly understand all these provisions. We will do a case study also on this. There is a summary procedure also. So in case the company has assets of book value not exceeding 1 crore, then the central government may order for winding up of the company by a summary procedure. And in this case, the official liquidator will expeditiously dispose of all assets within 60 days of his appointment. I have made a comparison also between winding up and liquidation process under the Companies Act vis-a-vis IBC. So this case study you can go through. And I think there is a video lecture also. Let me find out from the YouTube channel. I'll find out and post it in the group. Because in detail, I've discussed everything. This we have already covered. Then these are some of the points which can be covered in as a case study. Like in this case, the person who is he was a director in a company, he was a director of PNB, and he was issued a show cause notice. But the tribunal held that, okay, he is the head of some other organization, he cannot be roped in, and his assets cannot be attached in exercise of the powers under section 337 and 339 of the Companies Act. This is Nirav Modi case, basically. Then what are the situations in which the name of the company may be removed? So section 248, power of registrar, failed to commence business, cannot carry on business for 2 years and did not apply for dormant status. So if you are a company which is not carrying on in business for 2 years, then you have to apply for dormant status. If you do not apply, then your name may be removed after issue of notice. If your subscribers do not pay the subscription money, if you are found not carrying on any business, then this is very important. Company except section 8 can also apply on any of the above grounds after extinguishing all its liabilities and passing a special resolution. But section 8 company cannot apply for voluntarily removing their names. This is important. In this case, what happened is, the finding is that the tribunal must give a reasonable opportunity of making representation and of being heard before passing an order to the registrar, the company, and all the persons concerned under section 252(1) of the Companies Act. And this case study has been asked in some of the examinations also. So in this case, the company's name was struck off, and then income tax, they applied for reinstatement of the name because they had some liabilities which were to be recovered. So the authorized representative of the registrar of companies, they submitted before the tribunal that they do not have any objection to restore the name of the company. Then NCLT, they allowed the appeal and directed to restore the name of the company. But in this case, no notice was served on the company, but the company was arrayed as the respondent. So the ex-director of the company, and they said, okay, you have restored the name of our company, but you have not given us opportunity. So you must give us opportunity. So appellant submitted that section 252 subsection 1 of the Companies Act provides that before passing any order, the tribunal must give a reasonable opportunity of making representation and of being heard to the registrar, the company, and all the persons concerned. Rule 37 of NCLT rules also provides that the tribunal shall issue notice to the respondent to show cause notice. So in this case, the issue was whether the order given by the tribunal of restoring the name of the company is sustainable in law. NCLT held that they should have given the opportunity to the directors of the company also. As the order of NCLT is not sustainable, it is set aside. So they said, you again call the parties, both the parties, and after hearing them, then you pass the order. In this case, the situation is that section 248 of the Companies in no manner will affect the powers of the tribunal to wind up a company, the name of which has been struck off from the register of companies. Suppose the name has already been struck off, then whether that company can be wound up or not, this is this question. So question is whether during the pendency of winding up a petition, the name of the company has been struck off. In such circumstances, whether NCLT can proceed with winding up petition or not. So in this case, NCLT rejected the petition for winding up with liberty to the petitioner to file a fresh one as and when the respondent company is revived. Being aggrieved with this order, the appellant have filed this appeal. Appellant submitted that during the pendency of the petition before NCLT, the name of the company was struck off by the ROC. However, the NCLT has rejected the company petition on the ground that the company's name has been struck off by the ROC, and after revival, the appellants here in are at liberty to file the petition. Then this matter went to High Court. So High Court, they transferred this petition to NCLT principal bench, and they directed the petition to be amended to refer to the relevant section in compliance with the amended. NCLT should notice. This is also a case study which has been asked in the exam. So in this case, the documents placed by the appellant company, they failed to prove that it was carrying on business or it was in operation when its name was struck off. So sometimes the name is struck off and then the company, they take a plea that, okay, we were carrying on the business. But in this case, the name of the company was struck off and the appellant claimed that the company had been doing business. Then they were required to show the documents, but they could not produce any documents. They were required to show the return. They hardly showed 1 or 2 invoices and the address of the seller and purchaser of the same address. So NCLT found no reason to differ from NCLT as there is no substance in this appeal and the appeal is rejected. Issue was whether the ROC had served notice under section 248(5) of the Companies Act before proceeding towards striking off and whether appellant company was in business or operation or not. So this matter went to before NCLT because the name was struck off by NCLT. So NCLT held there is no doubt that the affidavit filed by the ROC attaching copy of the notice as per STK 1 and the affidavit which claims that such notice was issued to the appellant company as per the official records of ROC. Apart from this, this notice was published in official gazette also. And copy of notice STK 5 also gave the opportunity to the appellant to move the ROC if it was aggrieved. After such notice, the appellant made no effort to move to the ROC and put up its case that the appellant was in business or in operation. Thus, the contention that opportunity was not given is not accepted. When your name is published in the official gazette, copy of STK 5 is also given, then also you don't move, then you cannot later on raise the plea that you were not given an opportunity.
So the date on which it is being published is the date of dissolved, the company is dissolved, right, sir?
Dates are not here actually.
Okay.
But our ROC put sufficient proof that they had given sufficient notice. Now NCLT independently examined and regarding the merits of the claim that the appellant was in business operation, the documents filed before NCLT include 2 income tax returns. A return for 2016-17 gross total income was 504 and the income tax return claimed the gross total income was 1473. If the invoices are seen, seller is shown as this and buyer is this. If the address of the seller is perished in these invoices, it is same. So this is the same address of the appellant. So in this case, these are all fabricated documents. So basically they are not carrying on any business. So NCLT, they found no reason to differ from NCLT. So these are some of the case laws. These are some of the case studies which you can go through. Just a minute. इसको ना मैं थोड़ा सा ये है ना, एक मिनट कहाँ चला? तो मैं थोड़ा ठीक कर देता हूँ। व्यू ब्लैक एंड व्हाइट, यस, अब हो जाना चाहिए। कुछ खाली हो गया होगा लगता है, ये कुछ एक्स्ट्रा पेजेस आ गए इसमें। So we can independently discuss some of the situations, and I would like to invite some other persons also for this Companies Act. देखते हैं, let us see what happens. But in the meantime, you go through the video recordings on allied laws. There are various recording, I think 15, 16 recorded lectures are already there on various allied laws. At least you must go through those lectures, and you must go through the PPTs, which are available on my website. I'll try to again post them.
Okay, sir.
Thank
Sir,
you.
going back to IBC,
Yes, yes.
when the application is made under section 7,
Uh-huh.
adjudicating authority will have to hear the CD